be seated. Wisconsin versus Kristopher Torgerson, court PC of 860.
State appears by Assistant Attorney General Richard DeFore and Deborah Allen.
Kristopher Torgerson appears with his lawyer Thomas Luminol. Good morning.
There are a couple things, Your Honor, we need to put on the record. I believe his IL has one, I have one, and then there were some motions that were filed by Mr. Wilma last night relating to 90608 sub 2 evidence relating to two witnesses who are potentially going to testify today, one being Carnell Pearson, the other being Joshua Howard. And we should probably address those. We can do that either now or later, but now would certainly seem to be an appropriate time. We're ready to proceed on those.
Okay, but I wasn't aware anything filed, so I haven't reviewed them, so why don't we do it a little later?
That's fine. That's not a problem at all.
Okay, the other items?
So one issue from that I'm handling, it's very minor. We have a juror that was selected from Eau Claire. The court may recall that her father is a Marathon County Sheriff's deputy. They are short-staffed on security today. He was present in the courtroom earlier. My understanding is that he will not be present in the courtroom during any of the proceedings where the jury is present. I just wanted to place it on the record that we made Attorney Wilma aware, and I'm sure he's made his client aware, or we have now, but he will not be present when the jury is here.
Okay.
And the other issue, Your Honor, and I spoke to Attorney Wilmoth about this, but for reasons of security, for the safety of the individuals involved, we are asking that the court amend its media order so that the media be precluded from videotaping the faces or persons of three witnesses that are, actually four witnesses that are all prisoners at this point in time. Three of them in the Wisconsin State Prison System, and one that is a inmate in the Marathon County Jail currently. Those four are Adam Smith, Carnell Pearson, Joshua Howard, and Rebecca Torgerson.
Okay, and your grounds?
The reason, Your Honor, is that we're concerned about their safety. Two of them have already been attacked in the prison because of the fact that they've been cooperating in this case. As the court is, I'm sure, aware, prisons and prisoners are not very favorable to other prisoners who provide information to the state. And so two of them have already been attacked in the prison. And so we're concerned that all three of them could be subject to that. The fact these are being live streamed, we know that even in the jail, it sounds like some of this may be available to the prisoners that are there. Certainly would be available to people in the prison system who the defendant is well known to. Since he's been there for some time. And so we are concerned for their safety and would ask. We're not asking that they not be identified. We're not asking for anything like that, although we would appreciate if the media would not do that. But that has to, I don't believe the court can order that, but the court can, as part of the media order that they not be videotaped or filmed or photographed. And I would ask the court to do that, and I know Mr. Wilmoth has indicated he does not object to that.
Mr. Wilmoth?
No objection.
Not videotape, filmed, or?
Photographed.
Okay, and when do you expect to have the first one of these witnesses?
Today, Your Honor. I expect...
This afternoon?
Yes, not until this afternoon. Mr. Pearson will likely testify this afternoon. Mr. Howard may or may not testify this afternoon, depends on how far along we get. And the others will probably testify tomorrow.
Okay, then let's hold off till noon. Let me look at this and think on it, and we'll wait till noon.
Okay. Thank you, Your Honor.
Anything else?
Nothing before we bring in the jury from the state's perspective.
No, sir, nothing.
Okay. You may bring in the jury. seated. Go ahead.
I believe the state was done questioning Captain Matt Barnes, and it was going to be the defense turn to speak with him before we proceed. I'm going to ask for admission of exhibits 222, 223, and 239, and then the state would reference this witness.
Any objection?
Let me just look what they are.
You can bring them in.
There's the two photos right up there, and then the carpet sample.
223?
222, 223, 239.
No objection.
Okay, they are received. Captain Barnes, you're still under oath from yesterday.
Thank you.
May I proceed, Judge? Good morning, Captain.
Good morning.
The first thing I want to talk to you about is your interview on October 15, 2010 with a woman by the name of Brittany Lowe at the Waukesha Police Department.
Okay.
If you don't recollect that, I didn't mean to spring that on you right away. I just want to get that out of the way. If you need to look at your report concerning your interview with Ms. Lowe to refresh your recollection, let me know, okay?
Very well.
She's previously testified, so I want to ask you something. You recall that woman was the first cousin of Stephanie Lowe?
Yes.
Okay. And again, if you need your report, let me know. Did she tell you that on Friday night, October 8, 2010, at approximately 7:16 p.m., I don't really understand the approximately, but at approximately 7:16 p.m., she had a phone conversation with Stephanie Lowe? Ring a bell?
That rings familiar.
All right. Would you be more comfortable looking at the report to make sure I got it right?
Absolutely.
All right. May I approach to?
You may.
Okay. Base stamp 287. Take a moment if you want to look at that. First thing I'm looking for while you look is whether I got that right. She said on Friday, October 8, 2010, around 7:16, phone conversation with Stephanie Lowe.
She did provide that information.
And I think in kind of that same area of the report, she talks about various things that were discussed in that conversation, including Stephanie Lowe asked Brittany Lowe how many grams there were to an ounce. Do I have that right?
That's correct.
And then Brittany Lowe told you she was not sure. No. Then Stephanie Lowe asked Brittany Lowe what 42 grams would be.
Correct.
And then she told you that she was not sure what Stephanie was asking about 42 grams, but suspects that Stephanie wanted to know what Stephanie Lowe, should pay for 42 grams. Do I have that right?
Yes, you did.
Okay. I think not far from that area you just looked at, did she also tell you that Stephanie would hang out with people who were dealing drugs?
Yes, you did.
All right. That's all I got on that. Thank you, Kevin.
You're welcome.
The next topic is when you went to do search warrant number 1, October 11, 2010, you were with Mary W., Detective Mary W., whose last name I can't pronounce, and, go ahead.
Wargreens?
Yeah. And Detective Strobach, right?
Yes, there were other individuals there, but we were the three that arrived first.
Right, and it was Detective Strobach's job or responsibility for the most part to take pictures.
That was a component of his responsibility.
Right. He took a bunch, right?
I think there were 132.
Yeah. And yesterday you testified that you could review some of those photos and be able to testify that they're a fair and accurate depiction of what photos he took, what he took, right?
That's correct.
Okay. I want to show you a few things in that regard of those photos, okay? I'm going to show you what's been marked as Defendant's Exhibit number 100. May I approach from time to time with you?
May.
Thanks, Judge. Tell me if you remember what that depicts.
That is the kitchen dining room table. On that table are some items from our search. The rubber gloves, for example, that are there are the result. I'm sorry, go ahead.
No, that's okay. I just wanted, here's what I care about. Under that dining room table, it's hardwood floor, right?
That's correct.
And that's just adjacent to the kitchen, right?
Immediately north.
Is there any rug or carpet underneath that dining room table depicted that you can see from that photo?
In this black and white photo, which isn't as easy for us as if this were a color picture on my computer screen, I do not see a carpet.
We're going to try and do better on that.
Appreciate that.
Do you remember 6.5 years ago whether there was a carpet or rug under that dining room table?
I have no specific recollection of it.
All right, let's keep working on that. I'm going to show you what's been marked as Defendant's Exhibit number 101. Just tell me what that is. Black and white, sorry.
That is an image of a portion of the dining room table that is taken from the perspective of right outside the bedroom that I previously testified, I believe to be occupied by Stephanie and Eric Holmes.
Depicts a part of the floor underneath the dining room table, right?
Yes.
Okay, does that help you tell whether there's a rug or carpet there or not yet?
Well, I can tell you there's not a rug or carpet in this image. So.
And showing you what's been marked as, previously been marked as State's Exhibit 227 and 228. These are the good color stuff, okay? Tell me what that is.
They're both 227 and 228 are images of the dining room. 227 includes a little bit of the carpeted area of the family room, both with a portion of the dining room table shown in the image.
Do those help you out in color that there doesn't appear to be a carpet or rug underneath that dining room table?
There is no carpet or rug in either of these images.
Okay. Just so I don't forget, which I inevitably will, I'm going to move in at this time 100 and 101.
No objection.
Thanks, Pat.
That'll be received.
Let's talk now about the searches of the apartment. I don't know whether I'm going to divide them, but just talk in general about searches, okay?
Okay.
The initial one, I understand, was October 11, 2011, so that would have been Monday, right?
I believe it was a Sunday.
The 11th?
I believe the first search we did was on a Sunday.
Okay. Was it the day after Miss Lowe was reported missing?
Your Honor, just briefly from Attorney Wilmoth, you said 2011. I think that might be the confusion.
I meant October 11, 2010. Was that the first search warrant?
That's the first search warrant.
Sorry. It was a pretty complete search of those premises, right?
We felt that it was a complete search on that day.
Remember, you previously indicated in testimony related to this matter, you went through every cabinet, every dresser drawer, every kitchen door, every closet. Pretty thorough.
I'm not sure that those were my words, but I would agree with you that a member of the police department looked in all those type areas in the apartment.
Was there a knife set in the kitchen? Do you remember?
I have no recollection of a knife set.
Remember you tipped the couch over and looked underneath the couch? Remember doing that? Or at least the team did.
I don't have a specific recollection of the couch being tipped over, but that would be consistent with our normal practices of searching.
I'm just trying to establish you guys was pretty thorough, including like looking under cushions of the couch. That's what you typically do, right?
Yes.
Remember, you even opened up the trap door to the attic and climbed up there and looked around, right?
That was done.
Because anything you could find that could assist in the investigation of what happened to Stephanie Lowe was important to the department, right?
That's correct.
Was the toilet, any part of the toilet in the bathroom swabbed for DNA, if you know?
We're talking in the gross span of all the searches?
Yeah.
We're on day one.
Sorry, span of searches.
I don't believe the toilet specifically was swabbed.
Do you people have the ability to, law enforcement, to recover latent fingerprints?
Yes.
Was any fingerprint effort made on the scene? Any effort to recover latent prints made on the scene, if you remember?
I didn't hear the question. Could Attorney Wilmoth repeat it?
You read it back, please.
Question, was any fingerprint effort made on the scene? Any effort to recover latent prints made on the scene, if you remember?
I can testify that I'm not aware of any fingerprints utilized or taken as evidence. I don't have a recollection whether there were attempts to dust for fingerprints or whether there weren't.
Some items of physical evidence get sent to the crime lab for them to do that fingerprint evidence, right?
Yes.
Yeah, like remember there was some liquor bottles we learned, got sent to the crime lab for any kind of processing, including prints, right?
Yes.
But you couldn't send the toilet to the crime lab, so any print recovery would have had to been done on the scene, right? Or at least an effort.
I would agree.
Do you remember in your work within the apartment, there was this mirror resting on the floor of a hallway?
Vaguely. If you have a picture of it, that would really help me.
Well, I don't. Do you remember any swabbing? Well, you did a lot of swabbing, right?
Yes, sir.
Swab any mirrors that you recall? Outside the bedroom?
I do not recall swabbing weird.
Okay. Do you remember, again, 6.5 years ago, a dog gate? You know, one of those things that keep dogs in a room or outside a room?
I recall there being animals that lived there. There could very well have been a dog gate. It's not something I have a specific recollection of.
And you don't remember certainly doing any swabbing or fingerprint recovery from that item of physical evidence?
No.
All right. Did you, Captain, see, based on your training experience, any evidence of what we call, what you guys call, forced entry into that apartment?
No.
What is forced entry?
Forced entry could be a lot of different things. It could be a broken window. It could be what we would frequently see as a crowbar or kicking in of a door or using a device that would leave tool marks to gain entry, which would cause a lock or a handle to be manipulated.
Do you remember opposite Miss Lowe and Mr. Mahomes' bedroom, where you found the bulk of the evidence, that there was another bedroom?
Yes.
That would have been the one right across from Miss Lowe and Mr. Mahomes' bedroom with the bathroom in between, right?
It's on the south side of the apartment.
It had a box spring and mattress on the floor, right?
Correct.
Yeah, Coach? I'm going to show you what I've had marked as Defendant's Exhibit number 103. And tell me if you recognize that as some of Detective Strobach's work.
Yes, I do.
Is that a fair and accurate depiction of a portion of this second bedroom we're talking about? And I think it would be the south side of the bedroom?
Yes.
And it depicts, what, a couple of side-by-side framed windows, right?
That's correct.
Shades up.
That is also correct.
Do you remember checking, you or anybody with law enforcement, on October 11th, 2010, or thereafter, whether those windows were locked?
I don't recall checking whether they were locked. I know that we didn't observe any damage on them.
That was my next question. Nothing, huh?
No, sir.
You were concerned about that, whether there was damage to them?
Well, when we're trying to be as thorough as possible, we would check all points of entry and exit, especially in a case like this.
Let me offer at this time 103. Okay.
The 103 will be received.
So, you don't recall doing any swabbing or fingerprint recovery of that particular area? The windows I'm talking about in the spare bedroom?
I did not swab the windows in the spare bedroom.
I want to talk to you about that bathroom mop and bucket about which we talked yesterday, okay?
Very well.
All right. You know, we were looking, the photos that were taken don't depict the handle of the mop, right?
The photos that are here that I had the opportunity to look at in court do not depict the top of the handle. That's correct.
And you were asked for your recollection of the surface, and I think you said it was either plastic or metal, but not wood, right?
That's correct.
All right. And then the shaft of the mop appeared to have both plastic and metal aspects to it, at least as I looked at it. You agree?
Whether there was plastic or metal on the shaft,
Yeah.
I don't know what the shaft, so to speak, was made of right now. I believe it was plastic or metal, but there is another component to it, a lower portion of the handle that surrounds the main shaft, and I believe that to be plastic.
Right, and that's kind of what I was getting at. Do you recall it being one of those mops where you move that handle in order to wring it out?
I don't recall, but that's my assumption based on the pictures.
All right. You just talked about a handle. Is that the thing that you use to wring it out? Is that what you were talking about?
Yes.
And so it was and it didn't seem like the mop on the bottom was really nothing more than like a sponge type of thing?
When reflecting on this, I don't know that I ever looked. It was in dirty mop water. I don't recall pulling the mop out of the dirty mop water to look at that.
We know you swabbed the handle, right?
Yes.
And now I gotta be clear. When you're talking about a handle that you swab, are you talking about the device that rings it?
No.
You're talking about just the very top?
No. Let me be clear. I'm talking about all the above.
Did you, so you swab that handle that rings it, right?
It would be easier for me to explain the swabbing process of the mop handle. It's up to you.
Have at it.
Okay. Well, through the course of my experience, after really irritating the crime lab when I swabbed a piece of evidence with 22 swabs, I went down there. They referred to me as the 22 swab guy. I was taught that use 1 or 2 swabs for a large item. So if you think of the head of a Q-tip, it was used on all sides of that mop handle from top to bottom that I could reach, so that as much biological DNA type carrying material as possible could be collected on 1 swab. And so it's basically scrubbing the handle with the tip of a Q-tip from the top of the handle all the way as low as I could get on the mop.
So when that swab gets to the crime lab, and they say we found DNA, you with me?
I'm with you.
How do we know, if you're doing 1 swab for the whole thing, how do we know where on the mop the DNA was?
In that case, we give up the ability to say where on the mop the DNA was for the benefit of developing a DNA profile.
Got it. Okay. Did that item of physical evidence get analyzed for any prints, fingerprints?
No.
Was that because they would normally be recovered from that kind of surface?
No, in this case, we frequently have to make a decision on do we want to swab, which if we do that, it would very well affect the quality of a fingerprint if it were there, or we can opt for DNA. And my preference and experience has suggested that DNA is a better piece of evidence, not only to collect and have a higher likelihood of it being useful, but for the crime lab to give us definites based on their findings.
I understand. So once you do some swabbing, you've eliminated the opportunity to do some fingerprint analysis, right, essentially?
When you scrub the whole handle with a Q-tip, yes.
Got it. Okay. The bucket. Any swabbing or print efforts?
No.
I know that, and I don't think it was the first time you were there, but a subsequent time, you swabbed for DNA the faucets of both the bathroom sink and the bathtub, right? Maybe not just the tub.
I know I did the tub. If I have a report to reflect on that says I did the sink, I would agree that I did the sink as well, but I recall doing the tub.
Right. And you were thinking that perhaps the person who did the cleanup would have used one of those sources of water for the bucket to clean up, right?
That's correct.
And whether it was the sink faucets or the tub faucets, you would have sent those swabs down to the crime lab for evaluation.
Yes.
Got it. There were a couple of tables, side table type items in the main bedroom, right?
That's correct.
We've got on really what is the foot of the bed, so foot of the bed's good enough. We've got a table that was there with a bunch of stuff on it, right?
That's correct.
And it's on that table where law enforcement recovered the Don Julio tequila bottle, right? The one that was removed from the bed.
Yes.
All right. No use really doing any swabbing or prints on that table itself because it had like a cloth on it, right?
That's my recollection.
Yeah. And we know some swabbing was done of the Don Julio bottle, but you just got to make a decision what gets swabbed, where the effort should be, right?
Correct.
All right. And then we've got this other end table, the second table in the room of the end table variety, which would have been just to the south of where one would lay their head on the bed, right?
Yeah, since well, the jury knows north and south, if you're standing at the foot of the bed looking at the headboard, it would be on the right-hand side near the bed, which is on the south side. Correct.
Close to a pile of clothes and close to the door.
Yes.
It's on that table where there was a fair amount of blood recovered from one or more of the legs, right?
Yes.
All right. Any swabbing done on that table? Do you recall?
I don't have a specific recollection whether the table or that blood was swabbed. if you gave me a report that suggested that I did swab it, I would be more than happy to agree with that. If it's not indicated that it was swabbed or collected in evidence, then I'm sure that's the case.
But if it's like of a wicker variety, would you still swab it? I mean, does the surface matter whether you swab something or not?
I'm not sure where you're going with that, but I would say no. If there's something, it's possible to swab any tangible item. Some items are easier to swab, some are more likely to contain DNA evidence on them, but you can run a swab on probably anything.
Prints is different though. You got to have a certain, fingerprints is different. You got to have certain type of surface with the hope you're going to recover latent fingerprints, right?
I would agree.
And if you know, what kind of surface do you kind of need with for the hope you're going to get some prints?
Well, there's thousands of different types of surfaces, but if you have a piece of glass and someone sticks their thumb or their finger on it, the likelihood that the oils from the finger will leave a readable fingerprint are very high. The odds of recovering a fingerprint off a piece of sandpaper are very low because of the texture and the fact that there's enough points in the fingerprint that in order to come up with a conclusion that you have to have enough of the fingerprint, but you're not going to get a print off something rough like sandpaper.
Some of the swabbing we talked about yesterday, you didn't do until November 1, 2010, a subsequent trip over there, right?
Yes.
And Ms. Ayala said prior to that time, somebody said the scene was released prior to that time, right? Remember those words?
Yes.
So the thought was, well, maybe the scene's been contaminated in some way and those swabs could somehow be affected as they relate to the importance in this case. That was the concern, right?
I don't know what the concern was, but those were the questions that I answered.
Yeah. Well, you still did the swabbing on November 1st. You still thought it was important to do, right?
Yes,
Because it was on November 1st that you did the swab of the mop handle, right?
that's my recollection.
Do we know who had access to the place between October 10th and November 1? Other than law enforcement. When you guys released the scene, who else has access to it?
I would say that Stephanie's mother, Claudia, who we would go to get keys to the property when we would subsequently go back, would have access. But who had been in there, either with or without permission, I can't answer that.
But on October 11th, 2010, that bucket with the mop, and it was in that bathroom, right?
Yes,
And on November 1, 2010, when you did the swabbing, you were in the exact same spot.
correct.
I want to talk to you now about the safe and the drugs within it, okay? Because I think we got to clarify some stuff here, because I did some math, all right? It's not that, no tricks.
Appreciate that.
The safe in the apartment was found by Detective W in the main bedroom closet, right?
Detective Organese located it in the upper right-hand overhead compartment of that closet, correct?
And I've just been a little bit confused, so I want to make sure. It was hidden behind some white, item of clothing or blanket when Detective Organese found it, right?
Yes, it was behind a wedding dress.
And not only is it behind a wedding dress, but it's behind a shuttered or closed top area of a closet, right? There was like a shutter or a door that would close that, a hinge item that would close that top part, right?
That's correct.
And it was high enough that you, the tall fella, could reach it, but not many others could, right?
I would never be able to reach where the safe was without climbing on top of something, but I was able to hold the door open.
Got it. So it certainly wasn't in what is in law enforcement parlance, plain view when you went in there, right?
That's correct.
All right. You wanted to get into that safe because you wanted to see if you could tie the contents of the blood you saw in the bedroom with any blood inside the safe, right?
I don't think that's an accurate statement.
Pardon me, sir?
I would not agree with your statement there.
Hang on a minute, Judge.
You may.
Did you want to get in the safe because you believed there was the possibility that there would be evidence helping us determine what happened to Stephanie Lowe inside the safe?
Yes.
As you said yesterday, you felt the safe was very important to the investigation, right?
Yes.
We know there was no blood found on or in the safe, right?
That's correct.
Is it your understanding that safe for swabbing for DNA purposes or latent fingerprint recovery was going to be the responsibility of the Federal Bureau of Investigation?
Objection relevant?
I'm asking about the safe with the drugs and who was responsible for swabbing it for DNA or looking for prints. Is that relevant? We got to wait for the judge because there's an objection to that question.
Thank you.
I'm not sure the relevance, but it was an answer.
Do you want me to repeat the question?
My understanding of your question is, was it my understanding that the responsibility to process the safe would be with the Federal Bureau of Investigation?
Rather than you, rather than the Wausau Police Department.
My answer is no, that is not my understanding.
Okay, did you process the safe for DNA?
I did not know.
Did you process the safe for fingerprints?
No.
Do you know if any law enforcement agency ever did?
I am unaware of if a law enforcement agency processed the actual safe.
Do you know why the safe wasn't processed for DNA or prints?
My suspicion would, do I know? No. My suspicion is,
I don't think the witness should be suspecting that they did that false speculation, so if he knows, he can answer yes or no.
You don't know, right? You don't know why it wasn't processed?
no.
Would that have been something you would have wanted done in this investigation?
I don't have the involvement throughout this entire case to be able to answer that question for you.
When it was handled by you, Detective Wogernies, and or anybody there, did they use gloves?
Yes.
Why?
Preserve that item of evidence should additional testing, but we wear gloves throughout the entire time we're there.
And I'm talking about the safes. You wore gloves at the safe, why?
Well, my answer to you is we wear gloves the entire time we're inside the property processing.
Gotcha. I'll move on. What you found inside the safe is what you previously described as, quote, lots of crack, quick quote, right?
Yes.
As I understood your testimony yesterday, you indicated that there was roughly 36 to 37 grams of cocaine recovered in the safe, which would be worth in this community $3,600 to $3,700, right? Is that what I heard yesterday?
Yes.
And I think you said yesterday, based upon the $400 in the safe, that's the equivalent of 4 grams of crack, right?
That's correct.
I understood yesterday you thought 36 or 37 plus 4 additional grams means Miss Lowe or somebody connected to that apartment and safe had somehow, some way received 42 grams of crack, right? That's what you said yesterday.
We had a conversation in regards to that, but that's not what I said yesterday.
But it looked like there was some evidence of 1.5 ounces, 42 grams in this investigation, right? 36 grams plus 4, or 30, right, yeah, 37 plus 4. Remember that yesterday or no?
I do. I think the context of what you're asking me to answer, I'm struggling with right now.
Okay, well, let's see if I can clarify that. Ms. Lowe, or whoever was controlling that safe, maintained within it a bunch of packages, about 60, specifically 63 in number, right?
That's correct.
And all, you believe, about 62 were half-gram packages, roughly, right?
62 of the packages were reported to me by the individuals that processed it to be between 0.4 and 1/2 gram each.
They go for, in the community in Wausau back in 2010, $50 per.
That's correct.
You're aware that these drugs were sent to the crime lab for weighing and testing, correct?
Yes, sir.
May I approach? You may. I'm going to show you what's been previously marked as exhibit number 221, which is a stipulation between the parties. The only thing I'm going to draw your attention to is the last page. You have to keep it all together. Which is a Wisconsin State Crime Lab report authored by Robert Block concerning the drug evidence sent to him, correct?
That is correct.
Have you seen that report before?
No.
You've seen the likes of it. That's what they process after law enforcement sends contraband to the crime lab, right?
This is a Wisconsin State Crime Laboratory report. I've seen lots of them. I just haven't seen this one before.
I'm going to show you now what's been marked as defense exhibit number 102. Okay, yeah. And take a look at that and tell me if it looks familiar to you.
I am familiar with this document, which is a receipt of physical evidence from the crime lab. I'm not familiar with this particular document.
Okay. But you can tell based on your training experience that the two documents that I brought to your attention go together, which is the sending of the drugs in the safe to the crime lab, its processing, the results of the processing, and the return. Basically, make sense?
Yes, it does.
Got it. All right. And taking a look at those two reports together, what we have from the safe are 30 small Ziploc baggies. You with me?
Yes, sir.
And they're known as what is called GEM, G-E-M bags, right?
Gym packs, that's correct.
GEM packs. Where does that come from?
I think the original intent of the tiny little 1-inch by 1-inch Ziploc bag was to hold precious metals or gems. However, they have been repurposed for the packaging of controlled substances.
And at least we believe that each of those 30 gem bags or packs each contain 0.4 or 0.5 grams of crack cocaine for sale, right?
Yes.
So they're half-gram baggies, right?
With the total weight of the gem pack and the contents, the crack cocaine contents.
That's what I was going to get at. Right. Right. So you're saying that those 30 small Ziploc baggies, those gem bags, don't actually contain a half a gram of product, right?
That's correct.
So when somebody's buying one of those gem bags for $50, they think they're getting a half a gram of crack, but they're not?
The frequency at which that statement is correct, based on my experience, is pretty consistent. So the vast majority of the time, when purchasing illegal drugs like crack cocaine, it comes in light.
Less than you thought you're getting. When you just said light, right?
Yep,
So you're getting less than you thought you're getting.
correct.
But are you saying the purchaser typically expects that?
I think the frequency at which that occurs, I can only assume that they expect that.
Now, I think we're going to illustrate that more so with the following line of questioning. Robert Block determined, the crime lab fellow, that there were within those 30 gem bags, small Ziploc bags, a total of 8.675 grams total crack cocaine, right? That's why I brought you both those documents to make it easy.
Sure, just give me 1 second, please.
Yeah, sure.
That's what his report reflects, that's correct.
So rounding that figure up to 8.7 grams, you with me?
Yes, sir.
And assuming that the 30 gem bags have roughly the same amount of product in each gem bag, I got a calculator if you need help. Each gem bag actually contained 0.29 grams of crack cocaine with it, rounded up to 0.3 grams, right?
I will trust your math.
Don't. Nobody should trust me anymore, remember?
I don't, but I'll do my best with your.
I need you to do it for me so we have no doubt about trust.
Okay, you just close the, oh, there it is.
Don't erase my grandmother's picture.
I'll do my best.
30 gem bags, total 8.7 grams. What do you come up with?
0.29.
So they're short a half gram in that regard, right?
At that time, that's what this report reflects.
Let's move on to the 32 knotted plastic baggies. Now they're not gem bags. They're called something. They're not called gem bags because they're configured differently, right?
That's correct.
Could you explain to the jury what a knotted plastic baggie is in the drug culture?
Sure. One very common way to package methamphetamine or cocaine is to take your standard sandwich baggie, which is a lighter plastic, and you place the amount of drugs that you want to sell into that baggie and shake it to the corner. And I've never been able to replicate it, but you get a really tiny knot that pinches those drugs into the corner, and then the bag is just pulled from the knot. So you have a torn end above the knot, and you have the corner of the baggie containing the drug substance remaining. So it's a very small item.
Found 32 of them, right?
Yes, sir.
And expecting roughly half gram product within them, expecting.
I didn't expect anything. That's what was reported to me by the detective that processed those drugs.
Robert Block of the crime lab found there was a total of 11.57 grams total within those 32 small knotted plastic baggies, right?
Yes.
So if you round that figure up to 11.6, assuming each of the knotted plastic baggies have roughly the same amount of product, we're talking about, I came up with 0.36 grams within each. You with me?
I have 0.3625.
So if somebody's paying $500 for those knotted plastic baggies, they're getting a little short, right? $50, they're getting a little short, right?
If they were to buy them at the time that these were weighed by the crime lab, yes.
Well, there was no more in them at the scene than there was at the crime lab, right?
I would disagree with your statement.
Go ahead.
Well, crack cocaine, which starts as cocaine and then is processed into crack, which is a smokable version of cocaine, there's a liquid associated with it. There's a component of that process that requires drying and heating that. So my experience is cocaine that's being sold on the street loses weight as it dries. And so frequently when we collect an item of crack cocaine evidence, especially if it was manufactured, which is unknown to us, when cocaine powder was turned into crack cocaine, it loses weight as time goes on because it dries. It's simply the process of drying.
So really, there's a buyer beware component of this drug trafficking business, right?
I think buyer beware applies to lots of components of drug trafficking.
How about seller beware?
I think across the board.
Finally, so let me ask you this. If crack cocaine is of a poor quality, that's a bad and dangerous way of doing business, isn't it?
Objection as to all of this.
Sustained.
Within the safe, there was one knotted plastic baggie. Feel free to refer to the reports containing 5.8 grams of crack cocaine, right?
Which report are you referring to?
The block stuff.
Okay.
Maybe it lost some weight.
5.820 grams.
I rounded down. Now, this amount of crack cocaine was not yet bagged up into any approximate half-gram sale quantity, correct?
That's correct.
Yesterday, you talked about an 8-ball of cocaine, and this is just so I gotta make sure I'm clear on this. An 8-ball is 1/8 of an ounce, right?
Yes, sir.
And an ounce is 28 grams, so an 8-ball would be 3.5 grams, right?
Yes.
So that last packet was almost 2.3 grams more than 8-ball, right?
Correct.
So if you add up, and this is what I was getting at on the 3,600 plus the 40, and the $400, this is what I was getting at. If you add up all the crack cocaine in the safe found by the crime lab, maybe it lost some of its half. 8.6 grams in the 30 gem packs, right?
Let me just correct your statement before we get too deep.
Yeah, go ahead.
Everything was found by investigators of the Wausau Police Department and the Marathon County Sheriff's Department. The crime lab wasn't the one searching or finding these items.
No, I understand, but then it got to them, and they did the weight, right?
It was weighed as part of the processing by Detective Leckleitner of the Marathon County Sheriff's Department, who took that property from the scene to handle that for us. It was subsequently, sometime later, transmitted to the crime lab for testing, which also includes, through their procedures, the reweighing of that product.
Who's the detective with the L? What's his name?
Leckleitner?
He's with the Marathon County Sheriff's Department, right?
Yes,
But when he weighs it with packaging, right?
that's my understanding.
He doesn't weigh it just the pure crack cocaine.
Correct.
That's for the crime lab, right?
I don't know what the crime lab's procedure in weighing that, so I can't answer that question.
Well, take a look at the reports before you. Doesn't it indicate that they're weighing the product without packaging? Or no?
I can't read that and draw that same conclusion.
Well, assuming, just work with me here, assuming the crime lab really doesn't care much about the plastic and that they're more looking at the product, they come up with 26 grams of crack. You want to do the math of those three items. The 8.7, the 11.6, and the 5.8, about 26 grams, right?
Okay.
They did that math right?
Yes.
All right. So if 42 grams were delivered recently, hypothetically, again, that's $4,200 worth of crack cocaine in this count, right? If 42 grams were at some time delivered to that apartment, you with me?
That's the retail value, correct?
All right. In Miss Lowe's apartment on October 11, 2010, if the crime lab was just weighing product, and even if it, understanding that it might have lost some weight, what was left in that apartment was just short of an ounce, 26 grams, right?
No, you're taking a time at which the crime lab is weighing it, and you're asking me to make that the same weight that we would have found on October 11th, and they're two very different things. So
Even without packaging? I'm talking about what you would have found without packaging.
I haven't weighed the packaging, so you're asking me to do calculations and make statements that are really impossible for me to do.
Well, based on your training experience, what's the date of Mr. Block's report?
This report is dated February 4th, 2011.
So Block gets the crack about four months after it's recovered, right?
Please trust me that I'm not trying to be difficult with you, but when Block got the crack is unknown to me, because per the receipt of physical evidence, it was transmitted on November 5th, 2010, but everything goes into a priority queue with the crime lab. So at what point in time he actually weighed it or processed it, his report is dated February 4th. So all I can tell you is sometime between November 5th or 6th and February 4th, that processing that you're referring to occurred.
Look, here's what I'm getting at, and I guess I failed because of how crack cocaine changes volume or weight. $400 was found in the safe, right?
Yes.
If 42 grams were at one time delivered to that premises, it appears that some of it was sold based upon what was recovered, right?
Sold or used, yes.
Yeah. And you know from this investigation, we know that a half gram went to Trenton Phillips, who passed on to somebody else, right? Remember that?
That's my recollection.
Do we have any evidence where what was left compared to what was delivered, where that went? Do we know? Who it got sold to or who used it? We don't know, right?
So let me make sure I understand the question correctly.
Sure.
If we know a half a gram is gone and we're assuming there's more that's gone, where that other cocaine, other than the half a gram to Trenton Phillips, that's what you're asking about?
Yeah.
I have no knowledge of where that went.
Would it appear that more was sold than $400? You found $400 in the safe, right?
That's correct.
Would it appear, and you don't even know if more than $400 worth was sold? You don't know that, such that that money's missing, is what I'm getting at.
I don't know what I don't know in that situation. So I can look at the investigation and we can take some of the information that's available, but I couldn't tell you with any certainty what it was at one point in time, what wasn't there. I just can tell you what's actually in the safe.
So if 42 grams were delivered on or about October 8, 2010, you with me?
I'm with you.
And based on what was recovered on October 11th, you really can't tell at all how much is missing of that crack, right? We can't tell. Was I unclear? 42 grams were delivered on Thursday, October 8, 2010, presumably. You with me?
I'm with you.
Okay, you're in there on Monday, October 11th, right?
I think it's Sunday, October 11th.
No, but that's okay. I'm right about one.
I could be wrong.
Yeah.
It's entirely possible it was 6 or 7 years ago.
Yeah, you're there on Monday, October 11th. You find less than 42 grams, right?
Yes.
But we just really can't tell because how cocaine changes properties, how much truly was there, right?
Well, I know that the cocaine and the packaging weighed just under 37 grams. So I know what was there.
Right. Well, you know what the cocaine and packaging weighs, but you don't know how much actual product was still there, right?
I cannot give you a specific to that, no.
Hey, when somebody gets 42 grams delivered to them, does that count towards the packaging as well, or no? If I'm buying 42 grams, does the person who's selling to me say, hey, really only, 20 or 30 in there because 12 grams is packaging? Or am I really supposed to be getting 42 grams of product?
That would probably depend on your relationship with the drug dealer.
Got it. I think we've done about as much as we can do on this. Oh no, one other thing. Also in that safe, 2 plastic Ziploc bags containing smaller Ziploc baggies, right?
Yes,
Commonly used to package drugs, right?
that's correct.
5 empty clear plastic baggies.
I could see you reading from the report. It would definitely help me to have it in front of me to go through those things.
Don't worry about it. Digital scale disguised as a cell phone.
Yes.
Let's move to the blood evidence. Let me get that stuff out of there. May I approach to do that, Judge?
May. This is the back page to this.
Counsel, I don't know if you know if you put your notes down so that they're on the screen.
I'm okay.
Thank you, folks.
Thanks. Turning this. So I want to offer 102 at this time, which is the transmittal of the crack cocaine to the crime.
No, Judge.
Do you need the screens on or not?
No.
Okay. I can turn the screen on.
A lot of this talk about the blood evidence yesterday. I want to review a few things, okay?
Sure.
All right. When you arrived, one of the things that you thought was surprising is it really wasn't a scene with a lot of blood, relatively, right?
I would say that the blood evidence that was readily visible by us did not give us an immediate understanding of what had occurred there.
Remember telling Eric Mahomes you thought the amount of blood seen in the apartment was consistent with somebody punching you in the nose and giving you a bloody nose. Remember telling him that?
I don't recall telling him that, but that wouldn't surprise me that I did.
Okay. The amount of blood was not consistent with your experience of either a gunshot scene or a stabbing scene that resulted in a homicide, right?
I would not make that statement. If you'd like me to explain, I'd be more than happy to.
Not yet. If you just hold on. You remember testifying under oath, Captain Barnes, in a previous proceeding related to this matter in federal court?
Objection, Mr. Rowland.
I am impeaching. I'm making an effort to impeach by a prior inconsistent statement. That would be the relevance.
Okay. Go ahead.
Do you remember that?
Really vaguely.
Okay. April 15th, 2011, in the United States Court for the Western District of Wisconsin. Does that ring a bell with regards to the drug trafficking from that apartment?
Your Honor, we haven't received this statement, so I just, if he's using it, we need to see it before it comes in.
It's not my witness, Judge.
Well, you're still cross-examining the witness, so you need to do
Yeah, well,
that.
there's a lengthy transcript of the proceeding. I guess we'll take some time for that.
I think we might need a brief recess.
Okay, let's take a.
You know what? I'll tell you what. Not even worth it.
Okay.
Let me move on. Somebody do a pretty decent job, in your opinion, cleaning up that place after a homicide, based on your experience, what you saw? Take some time to do that, or would it be something that could be done in a short amount of time, based upon what you observed in the scene and your training and experience? If you don't know, so be it.
Based on my training and experience, effort was made to clean up some of that apartment. To make an assessment on whether it was a good job or how much time was used on that, I can't do.
Okay. But when you got there, when you saw what you saw, you were actually hopeful that Stephanie Lowe may just walk in, right? Based on the physical evidence, you weren't convinced that she had met her demise at that time, right?
That's correct.
The luminol work that you did, that you testified about yesterday, indicated that the hardwood floor area glowed from the bedroom door all the way down the hallway out the front door of the apartment. Do I have that right?
To the front door.
Up to where one opens it to exit, right?
Correct. Meaning the door that is at the top of the stairs to enter the apartment, not the bottom.
Not the downstairs steps, right?
Yes, sir.
The downstairs steps were hardwood floor, right?
That's correct.
And there was a luminol glow on that hallway to exit the apartment that you believe was an 18-inch wide strip, right?
That's my recollection, yes.
So this is, may I approach?
You may.
Okay. This is a 12-inch ruler, right?
Yes, sir.
Okay. So you saw a swath of luminol glow out that hallway, heading out that hallway for somebody to exit. That was this ruler, 12 inches plus another 6 inches, right?
Yes.
Is that marked or?
No. You believe there was bleach or blood all the way out the front door, right? Up to the front door, right? Along that swath.
I believe I testified to earlier that there was clearly a substance that illuminates with luminol, or luminol-like substance, and that bleach and blood both illuminate with that. And I think in my report I included I'm certain there are other items that also illuminate with that.
If the illumination, is that the right word?
Sure.
If that was as a result of somebody cleaning up, you would presume that it would be done after the body was past the front door, right? That would only make sense.
That would make sense.
Thanks, Dan.
Any redirect?
Just a little bit. Oh, okay. Can we have the screens on? All right, while we're getting that all set up, I'll run through some other stuff with you. You covered some of this with Attorney Wilmouth related to the drugs, and that was testified to extensively, so I'm not going to spend a lot of time on it. You spent a lot of time investigating drug cases in your history with law enforcement, correct?
Yes.
And you indicated that you have no knowledge as to whether or not the crime lab weighs the drugs with or without packaging, right?
That's correct.
But your understanding, and I'm not going to get into all those numbers again, is that over a period of about 4 months, would crack cocaine without knowing when it was produced or turned into crack cocaine over a 4-month time frame, would that lose weight?
Yes.
And could it lose a substantial enough amount of weight to return the numbers that we're seeing in this case?
I don't have any background and haven't done enough work to really have a scale to address that. I believe the weights reflected on the day we collected it are accurate, and I have no reason to doubt the weights that were collected by the crime lab at a date in the future. So I believe that that's an accurate reflection of the loss of weight of the particular crack cocaine in this case.
Okay. And I know that Attorney Wilmot asked you some questions about the raw product versus with packaging. When people buy cocaine or cocaine product, they usually buy it with the packaging, correct?
Most frequently.
In relation to the Luminol testimony, Attorney Wilmot asked you some questions as to whether the result of cleaning up, it would be more likely that somebody would do that once a body, if one had been present there, was past the front door, and you responded that's more likely, right?
Yes.
Okay. But you don't have any idea when cleaning, if any, took place that would leave those marks, if that's what they were from, on the floor?
That's correct.
Attorney Wilmot spent some time on the safe and asking you about swabbing it for DNA and fingerprints. When you and the other detectives were inside of the residence on October 11th of 2010, had the safe been broken into? Not by you. When it was located by Detective Wolvernace, it was still locked, right?
That's correct.
And it was still hidden, right?
That's correct.
So if the safe had been broken into or exposed, would you have treated it differently?
The priority of processing the actual safe itself, I'm certain, would have been a lot higher.
Because it looked as though nobody had found it until you located it, right?
Correct.
And then I think I only have a couple of things left. Could we switch the screens to number 2, please? Attorney Wilmot showed you what's been marked as Exhibit 103, and that's what, well, I can't do both, but I'm going to have you look at it again. Is that what you remember looking at with Attorney Wilmot that's been admitted into evidence? Is that the same picture that's being reflected on the screen?
Yes.
Okay. And through the powers of technology, we can zoom it a little bit. Attorney Wilmot had asked you if you knew whether or not the windows, when you were doing your investigation of 701.5 West Thomas Street, Stephanie Lowe's residence, if the windows in the spare bedroom were locked. That is in fact the spare bedroom, correct?
Yes.
Are you able to see the windows more clearly with the zoom in on that photograph?
Yes.
Are you able to tell us now whether or not the windows at the time you were there were locked?
No.
You can't tell from that photograph?
I don't know for those windows which way the latch has to be open. So, I mean, they all look consistent to be running parallel to the window.
Okay.
But I can't answer that question for you.
One second, I just want to make sure it's working. Attorney Wilmot had asked you why, or if it was consistent or not consistent with a stabbing or a knife or a gunshot wound, and I think he wanted to explain, but he said not yet. Did you want to expand on that further as to why you couldn't commit to it looking or not looking like a gunshot or a knife scene?
Yes, I would. I think it's important to recognize that unfortunately in the last 17 years of my career, I've been to scenes from batteries with assaults, homicides, and sometimes just accidental issues that result in people bleeding. And I think that each of those situations has shown me that you can't walk into a scene and say, this is what happened because of so much blood. I've gone into scenes that I'm like, someone has to be dead based on the amount of blood here, and then I'm talking to them the next day and they're like, oh, I cut my arm and I decided to swing it around and that's why there's blood on the ceiling. So I don't make any assumptions based on the amount of blood that's there. What the assumption that I can make is something's not right with blood in the locations that it was found in that room, but the quantity of blood didn't tell me someone was deceased. It just told me there's more to this story than that we have to figure out. This was it wasn't a whodunit at that moment, it's a what happened at that moment.
And you had indicated that you had been a detective for a number of years now. You're the captain of detectives. Have you investigated a lot of homicides in Wausau?
A lot? No. We're fortunate that the need that has not existed.
And specifically, I know you indicated you spent some time investigating drug cases. How many homicides, if any, have you investigated directly related to drug dealing?
This one.
That's another question.
You just say this one?
Yes.
Hey, just so this record's clear, the crime lab, they weigh the crack, they don't weigh the packaging, right? Or you don't know?
I don't know. I think it would be incredibly cumbersome to empty approximately a half gram of cocaine out of every gem pack that we talked about and then put the half gram back in and weigh the next gem pack when we're talking about 62 small packages of crack cocaine.
Well, I'm confused. So do they weigh, they just weigh the crack, right?
I don't know.
Can I approach?
I object to this question. It's been asked and answered. If we're moving past that, then
Or not?
he doesn't know if it's weighed with the packaging.
I'm just going to show him the crime lab report.
He's already asked you.
You can show the report, I'm not sure it's going to be helpful.
Does the report help you determine whether the Wisconsin State Crime Lab weighed the crack or the packaging? Or both?
It is unclear to me in reading this report whether the crack is empty from the packaging and weighed or whether the packaging and the crack are weighed together.
You worked in the drug unit for how long?
My overall experience where my focus was on drug investigation is about 3 years.
You would refer cases to district attorney's offices for charges, correct?
That's correct.
Charges would be typically based upon the weight of a drug, correct, and not packaging.
We would include the weight of the packaging every time we would refer the case to the district attorney's office.
Was it your belief that the state of Wisconsin was prosecuting people for drug offenses based upon weight of packaging or drugs?
I had not considered that prior.
I have nothing further.
Okay. Excused.
Yes, and release from subpoena. From the state's perspective.
Not from the defense, remains under the defense.
Okay, well, thank you. Would you like exhibit 103?
Okay, we're going to take about a 15-minute break here.